Hello, everyone. This is Annie Cartwright. I'm an attorney in Husch, Blackwell's education group. We're excited today to bring you today's presentation on best practices for termination, layoff, and employee restructuring. Before we start, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'll take a minute to highlight a few of the most important ones. If you have questions during the webcast, please submit your question via the question box. We'll try to answer everything during the webinar today, but if a fuller answer is needed or we run out of time, we'll do our best to answer later by email. We really do appreciate audience participation and encourage you to submit any questions you may have. If you have technical difficulty, please click the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list, which is an icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit in Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of this webcast will be available tomorrow for watching and sharing. Once it's available, a link to the recording will be emailed to you along with a certificate of attendance, and that link will be available for about 2 weeks. Joining me today is Kate Levesque. She's a partner in our St. Louis office at Husch, who focuses her practice on labor and employment law. She's been kind enough to partner with our education team and advises institutions on day-to-day employment matters, including termination planning, training, investigations, and litigation. So with that, we'll turn to breaking up is hard to do. The economic realities that you're facing as colleges and universities are shifting a number of higher education institutions to do things like reduce forces, close campuses, consolidate campuses, and we've been asked for guidance on these for a number of institutions. So we're here today to walk through some key planning steps. Here are the topics we're going to be discussing. We're going to start with a broad legal employment law refresher and drill down on some more specific areas that are particularly relevant to reductions in force and termination. As a backdrop, we are seeing a wave of institutional closures in the United States. This chart summarizes the number of institutions we've seen over the last several years, peaking in about 2013. The majority of closures we've seen lately are on the for-profit side. Some are due to more stringent regulatory requirements and more stringent regulatory oversight. But the for-profit side shares with the nonprofit side declining enrollment. It's rising out of a decline in the number of traditional college-age students in the country and more public focus on debt and price. People are taking a much closer look at whether and when they go to school. This is leading our schools to engage in reorganizations. For example, Georgia State University systems had campus consolidations in the last few years. A number of community colleges have had significant layoffs and position eliminations. We've seen several mergers. Wheelock College in Massachusetts is merging into Boston University. And we've seen closures by schools who simply have too few students and too little funding. We've seen it a fair bit in the Midwest with schools like St. Gregory's University in Oklahoma, the Memphis College of Art, Grace University in Nebraska. They're just straight up closing. So to get us started today, a poll question for everyone. My institution has considered or implemented a group termination or campus closing in the past 2 years. So in the past 2 years, has your school thought about needing to do layoffs? Has it thought about closing a campus or consolidating a campus and considered all of the ripple effects that go with that? These numbers are still coming in, but it's about as expected. A fair number of you have considered these approaches to dealing with financial and other realities in recent years. The focus of our presentation today is going to be on options for institutions that are faced with a need for change. It's most often because of limited funding, who have to make difficult decisions about finances, which often requires cutting human capital. These situations create, not surprisingly, a lot of legal risk. When schools move forward without careful planning, they face claims of discrimination and breach of contract, among other compliance issues. Whenever possible, it's really essential that you take time to consider your approach to restructuring your employment force. We understand that sometimes financial situations crop up and you don't have a lot of time to deal with these, but often you can see them coming down the road. Map out who's going to be terminated, map out what your legal requirements and legal timeline looks like, and then take time to look at whether your plans align with the law. So to set a backdrop, the backdrop that your lawyers are most likely to be thinking about when it comes to terminations, let's take a quick look at the ABCs of employment law. It is filled with acronyms. Here are just a few of the federal laws that govern employee and employer relationships. Most of them, at least the most visible ones, are focused on traditional non-discrimination. But keep in mind that employees who alert your organization to a variety of illegal activity, whistleblowers are also protected, and so are those who are subject to layoffs under statutes like the Workers Adjustment and Retraining Notification Act, or the WARN Act, or the Older Workers Benefits Protection Act, both of which Kate is going to speak about later today. You also have a variety of state and local laws that you need to comply with. Note that for educational institutions, you may have employees out of state whose state laws you need to consider. If you have distance education adjuncts who are working in another state, you may have issues with them under their state's local law, even if that law doesn't cover your main campus or your brick and mortar campuses. You may have to deal with state wage and hour laws or layoff laws that aren't necessarily WARN Act laws, but you may have additional notifications to keep in mind. Obligations that protect certain employees from adverse action are founded in state and federal law. You need to take care that your employment decisions aren't pretext for discrimination. I hope that's Employment Law 101 for most of us, and we understand that. When you're making decisions about groups of employees, make sure that protected classes are treated similarly to others. Keep in mind that when we have an employee who's complaining about illegal activity, be it non-discrimination or other illegal activity like working conditions, we need to protect them under whistleblower statutes and make sure that whatever you do throughout this process, you are documenting. In addition to keeping these basic discrimination type considerations in mind, also keep in mind that we all have contracts with our employers. If you have written contracts or agreements with your employees, like the express one in this picture, make sure that you're following that and taking it into consideration when it comes to issues like termination processes and severance. Your policies and handbooks are often, as you know, interpreted as contracts. Particularly take a look at your faculty handbooks. They will be key reference points for you and for your employees when they're evaluating how to respond to your termination plans, and we suggest that you take a careful look at them as well. Hopefully you don't have undocumented contracts with your employees entitling them to certain processes or privileges in the event of termination, but if you do, they may come into play in post-termination litigation or post-termination claims as well. So against this backdrop, where do we suggest you start when it comes to approaching a situation that may involve mass layoffs or a large group of employees losing their jobs? First, we suggest you take a team approach. This should be high-level managers who are capable of thinking under pressure, who are capable of applying these detail-oriented checklist types of items that you need to think about when you're going through this process, and people who can keep it confidential. Obviously, these are highly sensitive, highly personal matters, and you want to keep your team limited to people who can appropriately distribute information with guidance. We suggest that you involve your board early and often when considering layoffs of any significance. These layoffs can echo through the institution, not just with regard to PR, but also with regard to other governance issues, and you want the board's approval and involvement with your process. We self-servingly suggest that you involve counsel, either inside counsel or outside counsel. Seeking legal advice can provide privilege to your sensitive conversations, and they can also, your lawyers can also point out what we're trying to do here today, which is to point out some of the risks and help mitigate them as you go through. And consider whether you need to involve someone from your diversity office. At some point, you'll certainly want to involve someone in your communications or public relations office. Also think about who's going to make the ultimate decisions here if you're faced with options in which employees or positions need to be eliminated. Who's going to have the final say on who gets cut? And take an inventory of your controlling documents, not just those contracts that straight up address your employment situation, so your employment contracts and your handbooks, but also look to those that protect your institution. Contracts like non-competes and IP agreements, you need to consider those as you're walking through this employment process and how you will sort those out with terminated employees. One controlling document can certainly be a collective bargaining agreement under the National Labor Relations Act, where your reason for decision making is based on labor costs. You have a duty to bargain before ultimate decisions are made. Make sure that you allow adequate time for meaningful bargaining. Sometimes this comes into place late or comes into consideration late, and you don't really have time, leading to problems with your collective bargaining unit. Also give the collective bargaining unit appropriate notice of your tentative decision. It's up to them to request bargaining over the effects of decision, but generally they do have a right to do that. Certainly your faculty is going to want to be involved in these decisions, even if you are not directly considering faculty terminations. Likely any sort of significant layoff is going to have an impact on faculty. Most of you have shared governance structures. The AAUP certainly isn't a union, but we all know that faculty members can look to it for guidance, and it suggests that faculty be involved in this process when they're being impacted by a decision. And it suggests that tenured employees may only be terminated in the case of financial exigency. So make sure that you're looking at your faculty handbook and the provisions it allows for financial exigency if you're going to be terminating tenured faculty in particular, and use that as a guide to walk you through this process. We really recommend that you take a holistic view. Sometimes when we are faced with a scary balance sheet, we can lose sight of the ripple effects that terminating large numbers of employees have throughout your institution. Really, to the extent you can, think strategically about how your layoffs are going to impact your students. What sort of student services are going to be impacted? Is it going to impact your educational programs, particularly if you're laying off key faculty members, in a way that you're going to need to look to your accreditors for some sort of approval or reorganization? When you're looking where to cut, keep an eye on essential functions. So if you cut staffing in the finance office, know that you may be eliminating the one person on campus who knows how to do certain financial aid functions, or you may limit the office's ability to perform those functions correctly, so that down the road you're actually looking at a larger expenditure than you're looking at a saving when you're terminating that employee. Really just zero in on your mission when you're considering this and use it as a guidepost in making decisions about which faculty members or other employees can leave your institution. Also, again, when you're faced with a panic-inducing balance sheet, sometimes we forget to think big picture. We forget that sometimes we have alternatives to straight up laying people off. Most of you will have already considered non-personnel expense cutting by the time you're looking at a layoff. But if there is a way that you can offer, particularly if you're located in an area where other jobs aren't going to be available for your employees, can you offer reduced hours? Can you offer pay cuts? And is that something that might be attractive or more attractive than losing their job to your employees? Are furloughs or temporary shutdowns an option for you? A related approach is forced or paid, unpaid vacation. Are you in a situation where encouraging or even requiring the use of paid vacation could ultimately reduce your expenses? That can be a cost-saving area. Have you already implemented freezes allowing natural attrition to save on costs? If you stop filling open positions, is that going to, over the next few years, give you the same financial savings as would a layoff. And of course, when you're taking these approaches, you're still going to want to consider issues like meeting wage and hour thresholds. And these aren't easy approaches, but they can, for some institutions, save costs in a way that's going to limit any long-term damage you're looking at, particularly damage when it comes to institutional morale and other intangibles. To look at some more tangible ways we can approach actual terminations, I'm going to hand it over to Kate, who's going to talk about voluntary separation and other means of affecting your ultimate goals in terms of termination. Kate?
Great, thanks, Annie. So always the first thing that institutions generally consider are ways that they can separate individuals voluntarily, rather than looking at those involuntary plans which impact morale and the organization's overall culture. Voluntary separation programs also do that, but the huge benefit is that they are truly voluntary. The eligibility factors are laid out, the plan is presented to eligible employees, and then it's the employees who decide whether to accept the offer and end their employment or whether to continue to be employed. And the voluntary nature eliminates some of the hits that institutions generally take to morale and culture when an involuntary reduction in force is executed. The employees who are not offered the program generally know about the program, they know that it is voluntary, and they know that some of their colleagues might elect to participate in the program. And those who are offered the program and choose to accept the offer feel like they were the people who made the choice. So that's kind of the benefit of going through the voluntary separation program as opposed to the involuntary program. There's a lot of flexibility in how the program is designed. You can limit the program to only certain groups of employees with certain years of service. Certain employees just in the finance department, for example, and not in academic affairs or admissions. You can really tailor these programs to get what you need, or to hopefully get what you need. Because the downside is, because it's truly voluntary, you're not exactly deciding how many people are going to accept the program. And that's something that is left as an unknown until ultimately all of the employees have decided what they're ultimately going to do. So what are the goals of the voluntary separation program? One of the important steps, or really one of the most important steps when considering the voluntary separation program, is outlining those goals. You don't want to have conversations with your faculty or your staff members without knowing all of the details of the program. And so you really want to take the time that's necessary to sit down and to think through what your goals are. How many people are you hoping to reduce? What are the required costs of the reduction? What are the cost savings that you're hoping to achieve? And then also taking a look at your current employee population and how you are organized and what your structure is, and then looking at what organizational structure will be best for the institution in the end. You don't want to go through these programs with blinders on, because if you don't properly plan and if you don't properly look at your eligibility criteria, you could end up with everyone from one side of the organization accepting the voluntary program and no one in another side of the organization choosing to accept the program, leaving you with a lot of holes to fill on one side and maybe needing to ultimately move to an involuntary reduction in force program on the other. And so you really want to sit down and organize yourself and take the time to plan. Now, that's obviously assuming that you've got enough time, and time is one of the most important things that you want to consider. Because when you want to roll out the program, you need to back off of that to give employees enough time to consider and decide whether to opt in. And many times individuals who are organizing these don't take that time and don't leave themselves enough time to back off of the decision and to properly plan and then to give employees notice. For those of you who have ever used these types of programs or you've considered them and consulted the advice of counsel, you know that any time that you're using a group termination program, whether voluntary or involuntary, you want to have employees sign a release in exchange for the severance that you're offering. In other words, the employees are releasing any and all claims that may have arisen up to the date that they sign the agreement. You can never release future claims, but claims up to the date where they signed the agreement. And if any of the impacted individuals are over the age of 40, which almost always occurs in these scenarios, generally you're going to have individuals over the age of 40, and all of those individuals need to be given 45 days to consider the agreement and 7 days to revoke the agreement. And that's the time that they need to have with the severance agreement and a notice of group termination, which we'll talk about a little bit later, in their hand to actually decide whether or not they're going to elect to opt into the program. Generally, most institutions keep that timeline the same for individuals under the age of 40 as well. And that way you're not running on two different timelines and all employees are given the same messaging and the same timeline. But because of that, let's say you decide that you want to implement one of these programs on August 1st of this year. You would need to give notice and have the conversations with the impacted individuals no later than around June 15th or so. And given that we're nearing the end of May, which is hard for me to believe, but that means that you'll need to have your individualized agreements ready to go and a notice of group termination prepared and your conversations planned out prior to June 15th. And so ideally, these sorts of decisions will have been planned for much longer than that so that you can really look and really plan out who should be eligible for the program, whether you want to have some maximum set or other criteria that you can really put into it. Because people generally think about it too late, the planning is rushed, and that means that it's not always sufficient, and the results don't always get the institutions what they're looking for. So what types of voluntary separation programs exist? The most common types that I have seen are voluntary early retirement incentive programs. Ultimately, these programs are exactly what they sound like. And one of the common questions that we get are, well, is it okay because we're talking about retirement and sometimes the eligibility criteria is attached to age. And it goes without saying that in any of these programs, you want to make sure that they are non-discriminatory and they're offered to all eligible employees. And what we can tell you is that, yes, voluntary early retirement incentive programs have been deemed to be okay as long as they truly are voluntary and they are non-discriminatory. And so sometimes you have factors like this. This is going to be offered to all non-tenured faculty members. That's one eligibility criteria. The second would be you must be at least 60 years of age as of X date. That would be a second eligibility criteria. And the third could be that you must have 10 years of continuous service with the institution. So anyone with those three eligibility criteria would be entitled to voluntarily elect to accept whatever severance you're offering and to end their employment with the institution. And those types of programs have been deemed acceptable. But you do want to be careful because at times questions have been raised. For example, there's a case that came out of California where a retirement incentive program was offered only to individuals who participated in one of the institution's retirement programs and not another program. And it just so happened that the retirement program that was eligible was for individuals who were the average age of 55. And the other retirement plan, the average age of the individuals participating was 60 to 65. And the court said, well, maybe that's not 100% okay. So what I recommend anytime you're doing these sorts of programs is to always seek the advice of counsel. And we've got a question that came in about what about the 21 days? So in most cases, individuals who are over the age of 40 for a single separation are entitled to 21 days to consider a severance agreement and 7 days to revoke. The 45 days comes in when you are doing a group termination program that's affecting one or more than one individual, and those individuals are being offered a severance in exchange for a release. So the 21 days still exists, but that's when you're looking at a single separation for one reason. For example, if you're eliminating one position, maybe you're not going to be doing social media in-house anymore and you're going to use a third-party contractor and you have one employee doing social media. You can eliminate that one position and give 21 days to consider and 7 days to revoke. The 45 days comes into play when you're looking at doing something that would be broader than that. So when you're looking at offering a program to 25 individuals, even as many as, or even as few as 2 or 3 involved in the same program, a group incentive program or a voluntary incentive program, that's where the 45 days is going to trigger. And in those situations, you also have to give a notice of group termination. So those are, the 21 days is still out there. Those of you using the 21 days, don't think that it's gone away completely. It's just that now we're talking about these group programs. So we're in another universe in some ways because the period of time is so much longer. Another consideration, though, that you want to think about is how are you going to ensure that the program is truly voluntary? It's a really important piece of the plan. The employees cannot be induced to participate or to not participate in the program. In other words, once the offer has been made, no one from the organization should try to convince any eligible participant to opt into the program or to opt out. And that could invalidate the program because then it is not truly voluntary. You also need to consider how much of an incentive it's going to take to get the number of participants that you need. For example, if you're wanting to eliminate X dollars of payroll overhead or benefits overhead, you're going to have to think through how many individuals it would take to opt into the program. And you're going to want to tailor your incentive to meet the goals. Obviously, 3 months of severance pay and benefits would deliver fewer participants than, say, 6 months of severance pay and benefits. You might get more participants who are willing to opt in under that longer severance and benefit period. So what about the employees that you can't afford to lose? A lot of institutions shy away from doing these voluntary programs because you don't have control. They truly have to be voluntary. So once an offer is made, if someone is in the group of eligible participants, they get to choose whether they stay or not. You can somewhat tailor that by really looking at your eligibility criteria and limiting the participation to particular levels of employees or particular positions or departments or programs or locations. And by doing that, you're excluding from participation other levels or positions or departments, programs, or locations. And so you're going to really try to tailor this to only those employees that you could, quote unquote, afford to lose. I've also had questions about what would happen if too many people opt into the program. Obviously, you don't want to have a workforce without enough staff to operate because then you're going back in and it costs a lot to interview and onboard new employees. You can put caps in, and there are ways to do that, first come, first serve, or other creative mechanisms to make sure that you don't get too many participants. And it's all of these reasons why we really recommend that you always work with legal counsel to review those notices of group terminations, review your separation agreements, and to look at your eligibility factors and how you're setting up the program, just to make sure that no one could poke any holes in the way that it has been designed. So let's talk now about the involuntary side of things. So we're switching from the voluntary side of things to the involuntary option. As Annie mentioned, furloughs have been used by some institutions to save costs while not undergoing a full layoff. And essentially what you do in the furlough situation is that you tell employees or groups of employees that they need to take off X number of weeks of pay. So say 2 weeks without pay. And those employees, the programs can be designed in different ways. Sometimes you have employees choosing the week, so you'll say, okay, we're in summer session now. We need every employee to take off, every staff member to take off 2 weeks without pay. You can choose the full weeks, and you just need to give us 4 weeks of notice of which week you have chosen. That's one way to do it. Other ways to do it is to have kind of a shutdown period without pay. These programs, like the voluntary incentive programs, can be designed creatively, but you want to make sure that all similarly situated employees are treated the same way. In other words, you don't want to have 2 hourly employees from the accounting group or the finance department to be treated differently from one another, because those sorts of situations give rise to claims of disparate treatment based on protected categories. So you just always want to make sure that you're treating everyone who's in similar positions the same way. Also, when it comes to furloughs, you need to be very careful of salaried employees and making sure that the pay reduction would not violate the Fair Labor Standards Act and destroy their exempt status. In general, one way to do that with salaried employees who are not receiving overtime for the hours that they work because they fall under one of the FLSA's exemptions is to have exempt employees take a full week of leave, so to have the leave be in full week increments, and to make sure that the employees are not performing any work during the work week in which they're furloughed. And that means no email, doing nothing remotely. You wouldn't be able to call them and ask where something is. There's some arguments about de minimis work, but the best way to do it is just to make sure that employees who are furloughed are not performing any work. Otherwise, you would have to pay them. And for salaried employees, that means you would have to pay them for the full work week if they perform any work during that week. So that's a tangent about furloughs, but just something to keep in mind as you're going through these involuntary processes. Termination based on performance, individualized termination, is also an involuntary separation mechanism that you have to reduce and then maybe not refill a position, which could be some cost savings. And you would just want to make sure that you follow the policies and practices outlined in your handbooks and your faculty policies and any contracts that you have. And then finally, the reduction in force. This is the most common mechanism, and I'm going to spend a little bit of time talking about reductions in force and some considerations that you should have when thinking through those. But I want to highlight that often we've seen clients who want to handle or think that it might be an easier way to handle performance through what's called a position elimination or a restructure. And I should note that that is very risky. If you're not truly eliminating a position and you're instead changing it slightly or tweaking the position and then reposting it or refilling it with someone else, there's definitely a risk involved. We always recommend that where performance is the reason for the separation, that you go through the performance issues and handle them through your normal processes and procedures so that there aren't any questions or any issues. Going back to the furlough discussion, I have a question of why should the furlough be for 5 days consecutively for exempt employees? So exempt employees are exempt from overtime, and to be exempt, generally you have to be paid the same salary for the work week regardless of the number of hours that you work. So in other words, a salaried employee receives X amount of pay regardless of whether he or she works 30 hours or 60 hours during that work week because they're exempt from overtime. And so the issue with furloughs comes into play of, well, if a furloughed employee works at all during the work week, then they should be paid their normal salary. Now there are a few very small exceptions that might work in some situations, but the safest way for exempt employees, in other words, employees paid a salary regardless of the number of hours that they work, is to make sure that you pay them the salary if they work at all during the work week. Meaning if you furlough them, you want to make sure that they're off for the entire work week. Because if they work 4 days and don't work 1 day, they've worked during the work week, and so they would be owed their entire salary. Or arguably, the deduction from pay could violate the Fair Labor Standards Act, which no one really wants to have that happen. So let's look into the reductions in force. Again, just like with the voluntary separation, planning is key here. If planned properly and planned well, reductions in force can be a good option for reducing cost and right-sizing an institution and making sure that you have the right number of people in the right number of positions for the organization. So there are 4 approximately phases in planning for a reduction in force, in my opinion. The first phase is to evaluate the job functions and the positions that you have. These can be separated to different people within the organization to make this or to perform this evaluation. So let's say the president tells each program to evaluate the faculty and staff associated with their program or their school, and to look at whether positions can be eliminated within that subset. You can definitely do it that way, or you can have one person or a team of individuals look at the entire institution. You could do it that way as well. And the important thing here is that in phase 1, you're not evaluating the people. You're not yet looking at who are the people in those roles. You're just looking at the job functions and the positions and what roles you have and what roles could be eliminated. You're determining where you need to make cuts at this point, not who to cut. So in my opinion, that's phase 1. In phase 2, you plan how the individual selections will be made. And ultimately, you start to identify those individuals. Sometimes this is easy. Sometimes you're going to outsource an entire department or program, or you're going to not offer a certain program anymore that you used to be offering, and so you know that those individuals will need to be cut. Sometimes it's more difficult. For example, if you want to eliminate 3 out of 6 department assistants, you obviously need to make some decisions about who will be eliminated and who will remain. And that's where these situations get more difficult, and that's where the planning comes into key. You really want to look at what your selection criteria will be. And the good thing to do is to decide on your selection criteria, again, before you're looking at the individual people and deciding for this position, should we go with seniority? Sometimes organizations will want to look at performance, and they want to say, well, we'll select and we'll keep the highest performers and we'll let the lower performers go. You want to be very careful to the extent that you're looking at performance, because there's a lot of subjectivity that's involved. You're not looking at attendance where you can say employee A was absent for 6 days and employee B was absent for 4 days, but you're looking at something that's very subjective. And at times we see managers doing this and giving scores to each employee that are different or inconsistent with the scores that are given on performance evaluations. And that's not ideal because it makes it seem like you're trying to back into selecting a particular individual, which could give rise to employment claims. So you always want to look at your selective criteria, and the more objective the criteria can be, the better off, in my opinion, we will be ultimately. And then the third step is to conduct a preliminary impact analysis. So at this point, you've decided which jobs can be eliminated. You've identified how you're going to select the specific individuals, and you've come up with a list of who will be impacted. And the next thing that we always recommend that you do is to look at the individuals that are impacted and determine whether there are any patterns that are showing that would show any sort of discrimination or retaliation. Now, as a reminder, there are two different claims that employees can raise when there's a risk situation. The first is disparate impact, or disparate treatment, In disparate treatment claims, the employees must prove that they were intentionally treated less favorably than an individual who is not within their same protected category. So to do that, the individual has to prove that they're a member of the protected class, that they were qualified for their position, and that they've suffered an adverse employment action, and that that adverse employment action was because of their status in the protected category. So the defense to that is that the employer or the institution would show that they have a legitimate non-discriminatory reason for selecting the employee for the risk, and that is not a pretext for discrimination. So what we always recommend is that once you've selected your individuals, you want to go through and look at the likelihood that there could be these discrimination complaints. The second thing that you want to do is what I call a disparate impact analysis. So in disparate impact claims, an employee generally presents evidence that an employer's neutral policy, rule, or practice has a disproportionate negative impact on members of the protected class. In other words, you have a policy or a practice or a selection criteria that on its face was not discriminatory, but that selection criteria resulted in more individuals within a protected class being selected, and that was a disproportionate negative impact. Now, once the employee makes the required showing, the employer can defend itself by challenging the employee's evidence, looking at the statistics that the employee used, or proving that the policy or rule is job-related and consistent with business necessity, which is generally what occurs. To say, no, if there is any sort of disparate impact statistically, there is no discrimination because we had a valid reason for using the selection criteria that we used. The important thing in disparate impact claims is that intent is irrelevant. So in disparate treatment claims, the discrimination has to be intentional, but here the intent is irrelevant. And so generally what we recommend as part of your planning process is to run the numbers, which we at Husch Blackwell can do, many of your lawyers can do, and we look at everyone who is being reduced and the people who are not being reduced or not being impacted to determine if there is a statistical disparity that would need to be addressed. And in the case that there are any sort of disparities or statistical evidence, you would want to go back and look at those selections in more detail to determine whether changes should be made to your selection criteria or how defensible that individual selection is. And you don't just want to run the numbers for the institution as a whole, but also for any subsets that may exist. So now we've come to our next poll question. What would be your best practice recommendation on methods for terminating employees? Should employees be terminated via personal email, by group announcement, or an in-person meeting? And I'm hoping that this is a fairly simple one, but we'll give you a couple more seconds to get your answers in. These termination conversations are always the worst conversations that I think HR professionals or managers or supervisors ever have to have. So I'm never envious of that actual conversation. So via personal email got a small number, but most of you say an in-person meeting, and I would definitely say that is the way to do it to the extent possible. Now obviously if you've got an employee who's extremely remote, and you can't do a travel day for whatever reason, maybe you're going to do something by video conference or video chat or phone conference, but my personal best practice recommendation is to always use an in-person meeting. So like I said, this is probably, phase 4 is probably the part that everybody wants to avoid, and that is notifying the impacted employees. My recommendation is always to have more than one employee present the information. And generally, I recommend that someone from HR sit in or conduct all of the meetings. I think that HR can be a comfort to some employees, and they can kind of describe the logistics that the managers or supervisors might not know. Second, I recommend that for these conversations, employers just stick to the facts. Don't make any gratuitous comments about, what the employee might be doing after their service with the institution that could be perceived or received as condescending or insulting or inflammatory or worse yet, discriminatory. Comments such as, now you can just stay home with your kids, or retirement is just coming a little sooner than you anticipated, but we know you must have been getting close. Comments like that, I think, are made to fill the space, to fill the silence, and to try to make the employee feel a little bit better about what's happening, but it usually actually has the opposite effect. The best way to handle these conversations well is to plan. I recommend that you make a script of talking points, that you tell everyone the same message in general if you're going through a group reduction in force, and that you go through the specific issues that are related to this employee. For example, benefits issues, when their benefits will be terminated, what information they might be receiving, what the last day logistics are, any sort of severance offers and the timing associated with those. And then I also recommend that to soften this and to give a little bit better of a transition, you consider having an outplacement service provider available immediately following the notification to the employee. Maybe you're going to notify the outplacement services provider ahead of time and give the employee a packet and a number to call. But that can sometimes kind of soften the shock and let the employee start thinking about what the next steps are rather than the disappointment of the decision. One other consideration that employers often forget is whether or not WARN applies. And there's a federal WARN Act, which is the Worker Adjustment and Retraining Notification Act. But some states also have mini WARN laws or other laws that require notice to the employees or certain governmental authorities prior to a closing or large layoff, and you always want to make sure that you know whether the federal WARN Act applies or whether there's a state or local notification law at issue. And I won't take the time to go through every statute and every state law, but I will just tell you that those are out there, and then for today we'll focus on the federal statute. Under the federal law, if WARN applies, employers must give 60 days of notice prior to the layoff or the separation. And notice what must also be given to certain governmental authorities, and we'll talk about that in a minute. So the first step is to determine whether WARN applies. In general, employers are covered by WARN if they have 100 or more employees, not counting employees who have worked less than 6 months, and not counting employees who have worked an average of less than 20 hours a week. Private nonprofit employers and private nonprofit Private for-profit employers and private nonprofit employers are covered, and so are public and quasi-public entities that operate in the commercial context. And so you want to be very careful in determining whether or not you might be covered by WARN. And then you want to look at whether or not you're engaging in a decision that would trigger notice. For example, plant closings. An employer must give notice if an employment site or one or more facilities or operating units on an employment site will be shut down, and the shutdown will result in an employment loss of 50 or more employees during a 30-day period. Mass layoffs are also covered, so covered employers must give notice if there is going to be a mass layoff that does not result in a plant closing, but would result in an employment loss of more than 500 employees or 50 to 499 employees if they make up 33% of the employer's active workforce. So 50 employees is always something where, in my mind, I start thinking about whether or not federal WARN will apply. I'll tell you, a lot of the state laws are smaller than that and affect smaller numbers of employees. The general timeline is 30 days, but if there are waves of closings or layoffs, there could be a 90-day look-back period. And so you always want to be thinking about what's happened in the last 90 days or might happen in the next 90 days to determine whether WARN applies. If WARN is required, notice must be given to each representative of the affected employees. There's a state dislocated worker unit, and then to the chief elected official of the unit of local government. And so you can figure out who would need to be notified along with the employees. And the penalties here could be stiff. The penalties are 60 days of back pay and benefits, or a maximum of 60 days of back pay and benefits, essentially to get the employees to the amount of benefits and pay that they would have received had they gotten the notice. And then there's $500 in civil penalties per day of the violation as well. That penalty can be avoided under certain circumstances, but it can be pretty steep. So let's think and talk briefly about waiver and release agreements, some tips and tricks for these agreements, because they're almost always offered in these group termination programs. And again, you're going to see this 45-day notice period, and that's because we're focusing on the group termination programs. So they must be in writing, and they have to be signed by the parties. Some notarize, and that's optional, but I do think that it's good, especially if the employee isn't signing in front of anyone. Consideration is key, and consideration is the legal term for giving something in exchange for the release, and it has to be something that the employee is not otherwise entitled to. So if the employee has a contract that requires you to give them 30 days of notice of a separation, and you separate them without giving notice, you would have to give more than that 30 days. The release should include a full release of all federal, state, and local claims, including a specific reference to the Age Discrimination and Employment Act for individuals over the age of 40. You should consider whether you want to have an agreement that the individual will not reapply or be rehired by the institution. Consider non-disparagement clauses or a joint statement about why the employee was separated. Sometimes those are done, and sometimes they're actually attached to the back of the severance agreement. You should consider whether a confidentiality agreement makes sense, and obviously for public institutions sometimes that can be difficult, so you'll want to think through those issues. Remember that you can't include a waiver of future claims, and you should include the right to consult legal counsel and provide 45 days to consider the agreement in a group termination, although the employee can sign at any time. And then for individuals over the age of 40, they also must be given 7 days to revoke the agreement after signature. You'll want to make sure that you review and follow all payment terms, especially when COBRA benefits and ongoing benefits apply. Sometimes those can get lost in the mix of your benefits group and the people who are negotiating and authorizing and signing the severance agreement. I always think that it's best practice to end employment right away when the severance agreement is signed, but we do sometimes see situations where employers want to give notice and a small bonus, a retention bonus, and then have employees sign another severance agreement at the end of employment. And those just have additional concerns and issues that you'll want to think through in more detail. So our next poll question, by law, this group of employees must receive special consideration when offered waivers and release agreements in exchange for termination benefits. Is that members of a racial minority, pregnant or newly parenting employees, or those 40-plus years of age? And I think we've probably talked through this issue. And yes, those 40-plus years of age. So we've already talked about the consideration period of either 21 days or 45 days and the 7-day revocation period. But there is also the notice of group termination. When you're doing a group termination program, so when a waiver is requested in a connection with an exit incentive program or other employment termination program offered to a group or class of employees, you have to give that additional consideration time that we've talked about, and then you also have to have a group disclosure that provides a description of the class, unit, or group of individuals covered by the program, the eligibility factors and the time limits for participation, the job titles and ages of all employees who are eligible for the exit incentive or other program, and the ages of the employees in the job classification who are not eligible for the exit incentive program. And those last two criteria are generally done in a chart with the titles and ages and then a checkbox or number of employees who were selected or eligible or were ineligible. And those are forms that I generally recommend that you run by counsel because they have to be so specific. So what are some pitfalls in severance benefits? The first is that some severance programs and policies can be considered employee welfare benefit plans that are subject to ERISA. Generally, public colleges and universities aren't covered because ERISA does not apply to governmental plans, but private employers should consider the extent to which any severance program might be covered by ERISA. Sometimes that can be desirable, but sometimes that can be undesirable, and you just want to make sure that you're thinking through those issues. Also, you want to think through how you could amend or terminate benefits after they're offered or promised in a severance agreement. If you change your benefit plans, you always want to have a clause in the severance program that says, that it is subject to amendment or modification or termination by the employer, similar to how benefits are done for other employees. You want to think through paying for COBRA and how you'll do that. Some institutions decide to pay the insurance company directly, and some institutions decide to pay the employee, and then you'll want to think about the tax consequences and whether that should be pre-tax or post-tax payments. And anytime we're doing severance benefits, we always work in close contact with our benefits experts to make sure that we're considering any of these things, including the next bullet point, which is deferred compensation considerations, and whether or not Section 409A might apply. And finally, you want to think about the effective release dates of your severance agreement, because if you have a severance agreement and you have the consideration period and then the revocation period, you don't want your release to be effective until after the employee revocation period expires. In other words, once that 7-day revocation period expires, you want the agreement to become effective. If it becomes effective before the revocation period expires, then you might have paid out the benefits and then the employee revokes. And that's a difficult situation of how to claw back the payments, etc. So I think we've gone through most of the high points here. And I will throw it back to Annie to kind of wrap up and to conclude our webinar today.
Thank you, Kate. To wrap up, as you can tell from everything Kate just said and everything we've talked about today, planning really is essential when you're considering breaking up with your employees. Make sure that your board is involved early. Keep an eye on your policies, your procedures, your contracts. Use that holistic team approach that we talked about when coming at this issue. Be sure that you're including and involving and really listening to your stakeholders throughout this process, particularly your faculty. Once you do have a plan in place, be clear in your communications. Reinforce your messaging throughout the process and ensure that people in your leadership team know what the messaging is and know how to stick to it. Ensure that you have a PR strategy, including a social media strategy. And finally, ensure that you're in compliance with your legal obligations and ensure that you've taken time to approach this with a careful eye. So with that, I see we're out of time. I believe we've answered most of your questions, and to the extent we have not, we will get back to you by email. Thank you for joining us today on our program. We hope the information we provided was helpful and useful to you and your institution. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really is important to us, and it helps us in coming up with quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. A recording of the webcast will be available tomorrow for watching, and a link will be sent to you along with a certificate of attendance. The link will be active for a couple of weeks. The recording will be available as well, and be sure to join us for our next webinar on June 14th on the topic of the much anticipated Title IX compliance update. This concludes our webinar. Thanks, everyone.